Hello and welcome to GoalNews.org Video Edition, July 2nd, 2010. My name's Jim Wallace, Executive Director of Gun Owners Action League. Let's get right to the news. Obviously, big this week in the news is the McDonald decision from the United States Supreme Court, which absolutely now makes the Second Amendment a civil right, incorporated through the 14th Amendment and applicable to the states and local government. This is a huge victory for civil rights all across the country. And let's look at what the court actually said. This court, decades ago, abandoned the notion that the 14th Amendment applies to the states only in a watered-down, subjective version of the individual guarantees of the Bill of Rights. That is a phenomenal quote in the majority opinion. They actually said, "We hold the Second Amendment right is fully applicable to the states. We therefore hold that the Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller." This now becomes a civil rights issue. As Goal has been saying for many, many years, our members can actually be very proud of the organization. We were well ahead of the curve on this when we stopped using the term anti-gun and started using the term anti-civil rights many years ago, because that's exactly what it has become. Well, let's look at a few things that the opposition is saying across the country, which is kind of interesting because now they're saying that, well, the McDonald case doesn't change anything. Well, first of all, if it didn't change anything, then why did the opposition spend millions of dollars and countless man-hours trying to fight the Second Amendment from being incorporated through the 14th as a civil right? Well, the clear fact is that this changes an awful lot. Maybe not right away, but certainly over time, and that's what scares them to death. What they want you to hear is certain sound bites in the decision, both in McDonald and Heller, but only selective sound bites. One of them is the right to keep and bear arms is not, quote, a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. That, unfortunately for them, is only a little tiny piece of what that whole paragraph actually said. It actually said, obviously, that the right to keep and bear arms is not a right to keep and carry a weapon whatsoever in any manner whatsoever for whatever purpose. But it also said, we made it clear in Heller that our holding did not cast a doubt on such long-standing regulatory measures as prohibitions on the possession of firearms by felons and the mentally ill. It also talked about sensitive places like government buildings, schools, and laws imposing conditions on commercial sales. Whether those will be worked out over time, remains to be seen. But it was obvious the court was talking about restrictions on felons and mentally ill individuals, not just random restrictions and bans because they feel like it. They also said the Heller decision, reaffirmed by McDonald, also stated that the Second Amendment protects a personal right to keep and bear arms for lawful purposes, most notably for self-defense in the home. The court has made it clear that the Second Amendment covers everything for lawful purposes and especially for self-defense, which is really going to mean a lot of changes here across the country over time. Now, the court, not only did they decide in favor of the Second Amendment as a civil right incorporated through the 14th, but they piece by piece took up the opposition arguments against incorporation, and I want to quickly run down those for you. These are all up on the Goal website. You can find them if you want to read them in detail, but we'll quickly go through them for you. Believe it or not, the opposition actually argued that the Second Amendment should not be recognized as a civil right here in the United States because they said no other civilized country in the world recognized it as a civil right. Therefore, we shouldn't here in the United States. And the court actually said for that, for example, many of the rights a Bill of Rights provides for persons accused of criminal offenses are virtually unique to this country. If our understanding of the right to trial by jury, the right against self-incrimination, the right to counsel, were necessary attributes of any civilized country, it would follow that the United States is the only civilized nation in the world. That's a pretty damning statement against that argument. We also go to the balance theory. The balance theory, the municipal respondents maintain the Second Amendment differs from all other provisions of the Bill of Rights because it concerns the right to possess a deadly implement and thus has implications for public safety. The court actually said the municipal respondents cite no case in which we, the court, have refrained from holding that a provision of the Bill of Rights is binding on the states on the ground that the right at issue has disputed public safety implications. And the court actually goes on to talk about certain things with regard to, again, rights to trial by jury and so forth that might actually let people go. Again, a very damning condemnation of that argument. Local rule and experimentation. Municipal respondents therefore urge us, this is the court speaking, to allow state and local governments to enact any gun control law they deem to be reasonable, including a complete ban on the possession of handguns in the home for self-defense. Well, unfortunately, the court shot that one down too as well, and they said, under our precedents, if a Bill of Rights guarantee is fundamental from an American perspective, then that guarantee is fully binding on the states and thus limits, but not eliminates, their ability to devise solutions to social problems that suit local needs and values. In other words, it is a civil right. It's a national civil right. They can address crime issues, but they just can't simply pass laws on a whim because they feel like it. The litigation expense argument is just laughable on its face. The opposition to this case actually tried to state that if the court incorporated the Second Amendment as a civil right, that cities, towns, states, and so forth would spend enormous amounts of money in litigation fighting for the laws they have. And the court shot that down as well. They said this argument applies with even greater force to constitutional rights and remedies that have already been binding on the states. The right to free speech, all sorts of cases that have come down throughout history have forced cities, towns, and states to actually fight against civil rights, if you can believe that. The other one is the interest balance argument. Municipal respondents assert that although most state constitutions protect firearms rights, state courts have held that these rights are subject to interest balancing and have sustained a variety of restrictions. Well, unfortunately, the court shot this one down. In Heller, they said, we expressly rejected the argument that the scope of the Second Amendment and right should be determined by judicial interest balancing. This court decades ago abandoned the notion that the 14th Amendment applies to the states only a watered-down subjective version of individual guarantees of the Bill of Rights. And finally, one of the big arguments was the Second Amendment is a different right, unlike all the other civil rights that we have. Again, the court said, we stressed that the right was also valued because the possession of firearms was thought to be essential for self-defense. As we put it, the court, self-defense was a central component of the right itself. So not only did the court actually rule that the Second Amendment should be incorporated through the 14th as a civil right, they actually addressed all the arguments from our opposition piece by piece and shot them all down.